Hey everybody, how's it going? Welcome back to Copper Jacket TV. So it was big news, and it was good news when we found out that there was a nationwide injunction placed against enforcement of the ATF's pistol brace rule. Now, there had been prior injunctions to that from the FPC, Maximum Defense. That covered the FPC members and the plaintiffs like Maximum Defense, the GOA and their members. So there had been injunctions that were more narrow in scope prior to that. But when we got the nationwide injunction, it was awesome, and people started putting things back together, feeling a little bit more comfortable. The ATF had been just basically smacked down in several different lawsuits, and it was looking really good for us. Well, guess what? The ATF's back, and they want something done. Now, before we get started, I want to talk about today's sponsor, which is Delete Me, an amazing service that allows you to get your online privacy back. Believe it or not, there are data brokerage sites out there whose sole mission is to gather and sell your personal data. So what is Delete Me and how does it help? Well, Delete Me is a company that cares about your personal privacy. And so what they will do is collect your information and then search those data brokerage sites and remove your personal identifying information from them. Now, I personally have a Delete Me account, and in just the first week alone, they've already removed my information from 15 sites. Your dashboard gives you all of the information that you're going to need in order to control your online privacy. For instance, some of the data you can find on your dashboard are listings reviewed. In my case, there was 8,881, and the type of exposed data that they found. So if your online data privacy is important to you, join Delete Me. Use the link down below to save 20% or use the discount code COPPERJACKET. Okay, so let's go and talk about what's going on here with this whole brace thing, because it really seems like a roller coaster with ups and downs and peaks and valleys, and a lot of people just don't know where they stand. Now, the case that we're talking about today is a very important one, which would have massive effects, win or lose, on all other brace cases that are currently out there, and that's the case of Mock v. Garland, which involves the FPC and its members, Maximum Defense, and other plaintiffs. Now, in this case, the plaintiffs have already asked the court for a motion for summary judgment, basically asking for the court's judgment in this case. Instead of just granting the injunction, they want the court to rule on this. Well, just yesterday in hops the ATF, and now the ATF has filed for a motion for summary judgment as well. And you're just not going to believe some of the arguments they give as to why they have every right to do what they did. And even if they made mistakes along the way, they're just little ones, so it shouldn't really matter. Okay, so let's go ahead and start off with the whole minor error thing, which is not minor whatsoever. So one of the claims that the FPC and other plaintiffs are making here is that the ATF violated the APA, the Administrative Procedures Act, because what people were allowed to comment on, which was the proposed rule at the time, ended up being completely different than the actual rule that came out. There was no worksheets, none of the stuff that was actually proposed. I mean, well, some of it. Not all of the stuff that was actually proposed was in that final rule. So they took comments and then ended up with something completely different. And so they're saying that they violated the APA. Well, the ATF saying, look, it was just a little mistake. I mean, check this out right here. Now, it says it right here in C where they say any error in ATF's process was harmless, and they cite some different rules and stuff, but they basically are saying that, look, we know that it's different. It's not the same thing, but it involves the same issue, and therefore it should be considered a harmless error by the ATF, and we should be able to overlook it. So I mean, harmless error, my ass. There's nothing harmless about violating people's constitutional rights. But again, they don't believe that these things are protected by the Second Amendment or by the Constitution, even when they're attached. So, of course, why would they care about the APA? Why would they care about any administrative procedure? I mean, just take a look at this next one here. So, look at it right here. They say that neither the rule nor the NFA violates the Second Amendment. Plaintiffs contend that the Second Amendment protects the right to keep and bear braced equipped pistols, and that the rule, or alternatively the NFA, violates the right by subjugating those. Now, I know the agency doesn't like to hear this, but clearly the plaintiffs are right in this one, that it is protected by the Constitution and by the Second Amendment because, well, they're in common use for lawful purposes. And we know that because there's millions of them out there. We're not talking about a dozen kind of spread out between different states. We're talking about millions. If that doesn't constitute common use, I don't know what does. And then we're talking about for lawful purposes. A majority of these are used for lawful purposes. So therefore, braced pistols are in common use for lawful purposes and therefore fall under the protection of the Second Amendment. I don't see a problem with that argument whatsoever. It's much easier to argue that versus, let's say, an SBR or something else that has been highly regulated for decades, and finding common use or common use under those particular standards under the NFA might be a little bit more difficult. But these have not been regulated, and there's millions of people that have them, so they're pretty much plentiful and they are everywhere. So the common use test is definitely passed, and for lawful purposes we all know that to be the case as well. But again, remember, they don't believe in that. They don't believe that it's protected by the Second Amendment. So they're saying instead that they are dangerous and unusual, and that's why the court should ban them or allow them to ban them. Now, one thing I want to make clear is when I say ban them, I mean ban their use, because if you can't use something, it's banned from being used, then essentially it's banned altogether. Why would I want something that I could never use? Regardless, they basically say that, look, these are dangerous and unusual weapons. It says here, short barrel rifles are dangerous and unusual weapons. But here's the thing, they're not SBRs. We all know that. They're braced pistols. So basically what you're trying to do is you're trying to insert something that's not fact, something that's completely made up, but you're trying to insert it as fact to the court by calling them something that they are not. So it says here, courts also have overwhelmingly held that SBRs are dangerous and unusual weapons that are not protected under the Second Amendment. Again, making that insertion that this is what they are, when in fact, that's not what they are. They're braced pistols. They're not SBRs, and that's what this whole argument is about, but you guys don't seem to get that. Given this consensus and the rationale for it, another court in this district has declined to treat braced equipped short-barreled rifles any differently. Okay, so let's just take a look at this next paragraph real quick. I mean, I feel like their argument is just completely falling apart if they have to essentially lie and call things that they aren't. I mean, they already know they're playing a losing game. Plus, the argument really hasn't changed all that much to begin with. And we know that the plaintiffs in this case have a likelihood of success on the merits. But hey, they're swinging for the fences here. So it says here in, again, this is the brief that was filed by the agency. It says, although this court has found that, again, quote unquote braced pistol, so they don't like to use that word, but since that's the word that it actually is, they feel like putting in quotes would be appropriate, enjoy Second Amendment protections because they are, again, quote unquote, commonly used by law-abiding citizens for lawful purposes, which they are. Defendants respectfully submit, the defendants being the ATF, respectfully submit that the record and the case law lead to the opposite conclusion. Now, here's where they change it, okay, because this is their own definition. So this one does not have quotes. That braced equipped SBRs are dangerous and unusual weapons that are not constitutionally protected. First, as explained, the pistols that are typically equipped with stabilizing braces are not the type of compact, lightweight pistols that are the most commonly used firearms for self-defense. Now, nobody said they had to be in common use for self-defense. They just have to be in common use for lawful purposes, but that's this new thing that the left is trying to do. They're trying to replace, commonly used for lawful purposes. They're trying to replace the lawful purposes part with self-defense. And here's the thing about dangerous and unusual. One thing that you want to try and keep in mind here, for dangerous and unusual to even work, they have to be both. It can't just be one or the other. It has to be both dangerous and unusual. That's why that and is in the middle there. So you might have something that's dangerous, but it's not unusual because there's millions of them out there, which makes it pretty damn usual, right? So it has to be dangerous and unusual because they're not unusual. Even if they consider them to be dangerous, that clause doesn't apply. So that you can't use that, but they use it anyway. And if it is unusual, but it's not dangerous, then the clause doesn't apply either. It has to be both. It is an and, not an or type of thing. But that's what they're trying to do. So right now, the injunction still stands. Nationwide injunction, FPC's injunction, GOA's injunction. But this case right here is going to be a potential turning point because we have both the plaintiffs and the defendants in this case asking for summary judgments from the court. And whatever happens next is going to be a huge indicator as to what we're going to see moving forward with all these other cases as well. If the judge issues a summary judgment for the plaintiffs in this, likelihood of all of these other cases winning or just becoming moot altogether is pretty likely. But if the ATF actually wins their summary judgment in this case, that could put into jeopardy all of the other cases. So it's very important and definitely one to watch. And I know that I kind of mock it a little bit here and there, just because I feel like the defendant's arguments are so wrong and so terrible and so bad and so unconstitutional that it just deserves being mocked. But it's a very serious issue. Regardless, as it stands right now, injunction's still in place, but we'll see where this goes in the future. This just happened yesterday, so obviously things take time. I don't think we're going to see anything else about this now for the rest of the year, but it's worth knowing about. Thank you all very much for watching. I really do appreciate it. Please like, subscribe. You guys have a great day.